Our first question here from Facebook. This is regarding subleases. With a lease option, can you sublease it?
The answer is yes, as long as the lease allows for it. So you can sublease it. And frankly, if you're going to try to acquire property via a lease with an option to purchase, you better make sure your lease has a provision allowing you to fully sublet it.
Yeah, go right to the assignment and subleasing clause.
Right.
It's usually always there. And if it's a commercial lease, it's almost always going to say you can't.
Right.
I don't know what the default is in a residential lease, but
you can't. You can't.
It's typically not.
You're going to have to change that.
Yeah. So watch out for that. It doesn't mean that the landlord can't approve it. But that's what you're going to be going through.
The other thing is, if you're going to do a long-term lease with the ability to sublet or use it as a VRBO, like a rent, they call it rental arbitrage. If you're going to do something like that, the state lease prohibits the changing of locks. Well, you're going to want to change locks. So you're probably going to want to put a smart lock on there, especially if it's a VRBO. And in that case, you need to strike that language, because otherwise, if the landlord or soon to be seller under the option gets cold feet, wants to back out or whatever, they're going to be looking for any violation of the lease. And that could be one of them. And so make sure to put in there that you have the ability to change the locks, and change them without even providing the landlord with access.
We did get one more question. This one's a good one. Does a quitclaim work the same as a warranty deed as far as spouse relinquishing ownership rights over a property?
No, and you don't even want to use a warranty deed. But so let's just start with the idea of a quitclaim deed. They're not good documents. I'm just going to be frank. Don't use them. Title companies hate them. Now, granted, you're quitclaiming, which means you're not providing any representations or warranties as to title. You're just saying, hey, to the extent I have any interest in the property, I'm going to give it to you, or I'm relinquishing it to you. So I understand why people do it. Title companies hate quitclaim deeds. Warranty deeds are better, but really the document for a spouse in Arizona to relinquish ownership rights over a property is a disclaimer deed. That is what you want. You don't want a warranty deed. You don't want a quitclaim deed. You want a disclaimer deed. Can it be done through a quitclaim deed or warranty deed? Sure. They could, convey it to the other spouse as their sole and separate property. But the preference is a full-on straight up disclaimer deed.
Somewhere, somehow people got the idea that the quitclaim deed was this magic wand that fixed everything. I think my favorite one was I saw a husband and wife, and one of them died, and they owned it as tenants in common. So there was no automatic transfer of title to the property. So the living spouse just decided to quitclaim her deceased husband's interest to her. I was like, yeah, you can't do that. That would be great if you could do that. That would be an awesome workaround, but you cannot do that. So any other questions, Mayu?
There was just one more follow-up question. I feel like I can guess your answer. The best least option to buy price, it depends.
Yeah, it would depend. I mean, for example, let's say that you want to acquire the property subject to, but for some reason, you don't want to acquire it right away. And come to our class on May 4th, and we'll talk to you about why you may not want to acquire it right away and what those circumstances are. But in that case, the purchase price is going to be the payoff amount of the existing loan as of close of escrow. That's going to be your purchase price. So what's cool about that is you have a long-term lease and you're paying the mortgage. You're reducing your purchase price as you go. So, that it really is going to depend on the scenario.